Hi, this is Brian Wiklendt with Garfinkel Schwartz. I'm coming to you from our Maitland, Florida office, which is a suburb of Orlando. I'm lead counsel here. What I'd like to do is talk to you a little bit about what insurance companies try to do under the Defense-Based Act to get away with not paying on claims. And there are a lot of different things that they do. It's really tough to go alone if you don't know these tricks and you don't have an attorney that specializes in the Defense-Based Act. First, they try to deny the claim. That's the first thing that they're always going to try to do, is deny the claim. They do that in various different ways. First, they're going to talk about notice. Did you give adequate notice to your employer? If you don't know what the Defense-Based Act is, it's difficult to know what to do, and you have to rely on the employer to go through the correct process. So as soon as you get injured, you want to talk to the human resources people or your supervisor and say, how do I do this claim formally? How do I actually get the Department of Labor to understand and know that I have a claim here? That's one thing that they try to do. Next, they try to deny claims based on hiring a person that would be, say, a nurse case manager or someone that's going to try to get you treatment, and they're working for the insurance company, not you. They're supposedly helping you get the treatment you need and monitoring your medical care so that they can provide it for you. But a lot of the time, they're actually trying to find ways to figure out whether this is actually work-related, whether it's pre-existing, whether it's degenerative disc disease instead of an actual traumatic injury. They're always trying to put holes into what your true nature of your injury is. And so you want to be aware of that. You want to talk to a lawyer about that. You want to see how you should interact with these people that are hired by the insurance company to give medical advice and medical treatment when they may or may not be qualified to do so. They also try to deny claims based on an initial recorded statement. They want to send someone out very quickly, as fast as they can, to try to get a recorded statement from you without the aid of an attorney or knowing any of your legal rights. I would suggest that if they're asking for that you call an attorney right away. You can always call our office. It's free. I could give advice on that as to what you should watch out for in a recorded statement. They also do surveillance to try to deny the claim, to say that you're somehow being dishonest and you're not really as injured as you say you are, which could be an outright denial if a judge or someone believed that you were exaggerating or basically flat out misrepresenting what you can and can't do under the surveillance. After they try as hard as they can to deny claims, once they have to start paying on the claims, that's a whole nother ball of wax, and now they're going to try to reduce whatever they have to pay. Whether that be medical treatment that they're going to claim is unnecessary, meaning that you should have your own doctor. If someone recommends surgery, you should have a medical opinion regarding why that is so and how they came to that resolution, so that they can't fight with an independent medical examiner, which is what they do in that circumstance. And they try to find a doctor that's an independent medical examiner that they hire and pay to get a favorable medical result for them, meaning that surgery is unnecessary, maybe injections are unnecessary, that kind of thing, to try to avoid paying the correct medical treatment for the correct medical treatment. After that, it still goes on and on. They're going to try to reduce your benefits based on what's called a labor market survey. Once you get back on your feet, they're going to try to find jobs around your area that you're qualified to do, that they claim that you're qualified to do, that you can also physically or mentally do as well. A lot of those times, we believe that those jobs, some of those jobs, or maybe all those jobs, are completely inappropriate for what you can do actually physically or mentally based on the state that you're in. They try to find obviously the most expensive jobs so that they can try to reduce your weekly compensation benefits. And they'll try to do that throughout time. They'll keep trying every 6 months to a year. They'll send you to an independent medical examiner, or they'll do another labor market survey trying to find jobs that they could prove to a judge that you can do, even though you don't think you can do them. So you want to make sure that you have a lawyer, someone that knows how to fight against those types of things. They also have functional capacity exams that they give you to try to get you to exert yourself, so they can say that you're actually more healthy than you are, that you can lift up to a certain number of pounds, that you can bend over, that you can crouch, that you can lift your arms over your head when maybe you can't. That's called a functional capacity evaluation. They use all these things hand in hand to try to get you back on your feet, maybe faster or forever, in terms of reducing whatever their exposure is on your claim. And like I said, they have a vast resource of knowledge, experience, people and money to just constantly and continuously try to reduce your benefits. So it's just not worth it, in my opinion, to go about this alone. Sooner or later, they're going to use one of these tactics, regardless of whether you think they're doing the right thing or not. Sooner or later, they will. It's just in their nature. So again, call me anytime. It's free. 24 hours a day, we have an answering service, and I can get back to you, or someone here can get back to you and give you the advice that you may need. Again, it's always free to contact the office and ask some questions. When you hire an attorney, if me, for instance, for example, you wouldn't have to pay me. If I get benefits for you, I get paid directly, separately from the insurance company based on my hourly rate. So if you have any questions regarding this, or if you are in the process and you are a Defense-Based Act claimant, and these things may or may not be happening to you, it's always worth it to get knowledge so that you have enough knowledge to fight against the insurance company. Again, thank you for listening. This is Brian Wiklendt. Good luck and be safe.